Okay, well, why don't we get started, because the short time I have to speak will give people an opportunity to come in and they won't miss anything remotely important. So, um, hello everyone. Thank you all for taking time out of your busy schedules to join us this afternoon. My name is John Guskowski. I am the co-chair of the Government Relations Committee for the Connecticut chapter of the American Planning Association. I'm really just happy to be saying that we're piggybacking on the outstanding efforts and expertise of many others. Connecticut chapter of American Planning Association is very happy to be co-sponsoring this program along with CAZEO and Desegregate Connecticut to kind of present some of our favorite legal and legislative experts to talk about what happened in the legislative session, particularly in those mysterious and frenetic last hours of the passage of the implementer bill and some of the special session legislation related to cannabis. So I am very grateful for Sarah Bronin and Rich Roberts and Ken Slater being able to join us. I thank Robin Newton and Mike D'Amato from CAZEO for co-sponsoring this and really doing the hard work of putting this together. And thank Evan Seaman and the program committee from CCAPA for bringing this all together and making it available for continuing education credits. So with that, I thank you, and I'll turn it over to Robin.
Thanks, John. I really don't have much to say because John sort of just did all the thank yous, but on behalf of CAZEO, I want to thank all of our speakers, Attorney Slater, Attorney Roberts, Sarah Bronin, Nick Abbott from DesegregateCT. We really appreciate you guys taking the time to fill in our members on what happened in this past legislative session. There's lots that had to do with land use, and we always feel that it's really important that our members, at least at CAZEO, and I know CCAPA, that they understand what that legislation means for us, in our towns and cities, and that we implement it in the correct manner. So we're really excited to have you all here today. I'm not sure who wanted to start first, so I guess I'll leave it up to Sarah or Attorney Slater. Who wants to go first?
The only thing I want to just jump in quickly and mention, we are recording this, so we'll do our best to make that available to folks. Because I know a number of people had asked about that. And for those of you that did submit questions ahead of time, we've passed those off to everybody. So they're going to do their best to incorporate your questions into their presentation. So hopefully we've covered that. And if we have some time, we'll try to see if we can follow up and give folks time to ask questions. I think that covers it on my.
We can go if that's all right. I have my presentation queued up. So hi everybody. I am recovering from a small dental surgery. So sorry if I look a little funny today, but I'm Sarah Bronin, for those who don't know me. And I'm here with Nick Abbott, the Deputy Coordinator of Desegregate Connecticut, to talk about Public Act 2129, AKA HB 6107, AKA much of SB 1024. Before we really get into the details, though, I did just want to say there's something even bigger that happened, I think, this year than the bill, and that is that there was a ton of public engagement about zoning. So I think everybody on this call is engaged in planning and zoning through their job or through their through other work, volunteer work. And I just hope that it was gratifying to you as it was to me that so many people were talking about this issue this year, because we really think that more conversation, more knowledge about these issues can really help to improve the overall legal regime. And we saw that in op-eds and editorials and so on throughout the year. So with that, I'm going to turn it over to Nick, who's going to talk more specifically about the reforms.
Thanks, Sarah. So we can jump right into some of the changes brought by HB 6107. Which, if you want more details on or some more information, or just forget anything I've mentioned here, a lot of the information I'm going to share, including some more details on each of the individual parts of the bill, is available on our website at the link on this slide, and I think helps to flesh out some of the granular details of each one of these proposals. So there's two broad categories of changes that were brought by the bill. And those relate to things that zoning codes shall do and things that zoning codes shall not do. So I'm going to start with what affirmative requirements the bill requires town zoning codes to implement. And the first of these is that it requires towns in their zoning codes to affirmatively further fair housing. And I should add, actually, there's a third category of things that towns may do, which I'll get to at the end. So this concept of affirmatively furthering fair housing derives from federal fair housing law, but is not enforceable via a private right of action. So Connecticut actually became what we believe is the first state in the country to include this requirement in its Zoning Enabling Act, as opposed to a mandate for state agencies to think about this when they're administering programs. So we think this is a great first step, both symbolically, but also in a way that has real teeth, that requires zoning codes to affirmatively further fair housing rather than just abstaining from discriminating. Another requirement in the law is that it requires town zoning codes to consider their regional impact as opposed to just their impacts within their town boundaries. It also requires the towns to promote the efficient review of proposals and applications and the protection of historic, tribal, cultural, and environmental resources, which were not currently considerations within the zoning enabling statute. A few other requirements that were added to the statute is a requirement that zoning codes promote or provide incentives for distributed generation of energy, which particularly in the past 10 to 15 years, we know is really important, has a ton of potential and an important consideration for zoning codes that may, rather than promote these uses, get in their way. Another is that they may provide for floating or overlay zones. As you may know, lots of towns already have floating or overlay zones, but the legal status of those zones was actually only expressly provided for, I believe, for New Haven. And so this kind of codifies existing practice and puts it on more solid legal grounding in state law. Another may is that towns are allowed to use vehicle miles traveled as a standard for evaluating the impact of new development rather than existing standards. So they may still use existing traffic standards, but may also draw on vehicle miles traveled, which in our discussions with traffic engineers, oftentimes provides a better estimate of the actual traffic impact that comes from a new development. And then this is actually in the shall not category. So these are prohibitions that the law adds to the zoning enabling statute. So first is that towns may not require a minimum unit size in excess of what the building code or any public health regulations require. Already in the late 1980s, there was a Connecticut State Supreme Court decision that put such minimum unit size requirements on unsteady legal ground. But what we found in the course of conducting research and putting together a zoning atlas on all zoning codes in Connecticut was that a lot of towns maintained a minimum unit size in possible contradiction to that state Supreme Court decision. So this codifies in state law that those minimum unit size in excess of what the building code or public health requirements are not allowed. Another prohibition that the bill adds to state law is that it does not allow towns to cap the total number of multifamily housing units, which is something that we saw in several towns across the state, that in addition to fairly restrictive underlying policies, in addition, if a town had already produced a certain or had a certain number of multifamily units, that overall cap would apply. And the change in state law eliminates that cap. And then finally, a change that drew a lot of attention, but we think puts our state on more solid ground, is it removes the word character from the zoning enabling statute and replaces it with immutable character and replaces it with physical site characteristics and requires, by replacing that term character, which we know can be subjective and not particularly reducible to clear physical qualities, we think that we're making sure that towns are having more explicit express criteria as a basis for their laws. And similarly, it disallows towns from denying an application for immutable characteristics, source of income or income level. One kind of broad section of the bill that we prioritized was capping the amount of parking that individual towns can require. And we've seen increasing traction across the country for states considering similar legislation. And so what this bill does is it caps minimum parking requirements. And as the slide points out, it's the fourth to reform parking, but the first for all uses. So that is not just for affordable housing. And what it caps minimum parking requirements at is 1 space for studios or 1 bedrooms and 2 spaces for 2 bedrooms or more. In the course of our research, we found that a lot of towns, although a minority of towns, required parking in excess of these requirements. And some even required 3 parking spaces for a new studio apartment, which we know is not only far in excess of the amount of parking that's required for a new development, increasing costs and that are passed on to consumers, but it also incentivized car-centric infrastructure and sprawl and the demolition of open space to build more parking. So this kind of sets a very sensible cap in line with really the higher end of what would be needed. Towns are still able to opt out of this requirement, which was a change that was added relatively late on in the legislative process. However, the opt-outs are somewhat difficult to achieve. So it requires both a 2/3 vote of a legislative body. So in towns that have a city council or a representative town meeting, that body has to vote by a 2/3 majority to opt out. In towns that just have a town meeting, that body is the Board of Selectmen. And so in addition to that body, there also needs to be a 2/3 vote of the Zoning Commission or Combined Planning and Zoning Commission. So it is our hope that a few towns will opt out from this requirement, but there is still that escape valve should towns choose to exercise that option. And then another key signature piece of the bill relates to accessory dwelling units. So what we found in the course of our research was that a majority of towns in Connecticut did allow accessory dwelling units by right, at least somewhere. And about 50% allowed accessory dwelling units by right on a majority of their zoned land. But what we also found was that there is a host of different size and occupancy requirements that impeded their actual development. So what this bill does, it sets a uniform standard statewide that towns may then exceed, but sets a uniform standard so that we're actually able to set reasonable regulations to facilitate their construction. So the bill requires that towns allow accessory dwelling units in all places that allow a single family home. They must allow accessory dwelling units to be attached or detached. In terms of size, they must allow them to be at least 30% of the floor area of the main dwelling unit, or 1,000 square feet. They can exceed that size requirement, but that's a floor. They can't apply additional building code or architectural standards that aren't applicable to the main unit. But at the same time, the bill does allow municipalities to regulate short-term rentals, for example, to ban Airbnb, or to attach owner occupancy requirements for either the ADU or for the main dwelling unit. Similarly to the parking provision, there was an opt-out provision added to the bill, which allows towns to opt out. But this one, unlike the parking requirement, is phased out in time. So towns within the next year and a half, exactly a year and a half as of today, can opt out of this provision using the same thresholds for the parking requirement. But if they do not opt out by January 1st, then these provisions do become mandatory. And then a few miscellaneous items in here. We had certain proposals that were in our original bill, or other proposals that we wanted to flesh out more through a working group. And so there will be a task force that is convened that will be charged with developing a form-based code. So we've seen towns and cities throughout Connecticut overhaul their zoning regulations and move more towards a form-based code. And the product of the working group would hopefully allow towns to provide them with an extra option to get there. In addition, the commission would be charged with examining sewerage challenges and alternative septic possibilities, and making recommendations for ways in which towns or state law could be modified to allow for those uses. And then the last piece, which we're particularly excited about, is a new requirement of training and certification, which is effective now for those who serve on local planning and zoning commissions. And what the requirement is that those commissioners complete 4 hours of training biannually, so every 2 years, and that this requirement also applies to zoning enforcement officials. So not a particularly onerous requirement, but one that still provides them with the information and knowledge of relevant, not only planning principles, but also fair housing laws and state zoning enabling laws, so that they can enforce and enact those laws through their work. And then just to close, again, a reminder that all of this information and some more information on these proposals is available at our website, DesegregateCT.org/HB6107. We thank all of the members who are on this call or not on this call, but who contributed to these, but I'll turn it back over to Sarah.
Thanks so much to the coalition members, including CAZEO, the Connecticut chapter of the APA, who worked on all of these issues. And there's a big group at this point, over 70 organizations. And just to say, to reinforce, all of these organizations, not all of them were in the planning space, but so many advocates have pushed for these issues over the years, and we were finally able to get it over the finish line, I think, in part because of their years of work, but also in part because of the broadened conversation. So I continue to be convinced that the more people know, the more they'll push for reforms. And hopefully that will be seen as a big benefit as we continue on this journey of trying to improve land use locally and across the state. So with that, we'll turn it over to the next presenters.
Thank you. Ask me before I get into some of the legislation. One thing that came up very recently that relates to zoning enforcement is a case that was issued in June, which is Farmington-Girard versus the Hartford Planning and Zoning Commission. And there's a couple of unusual facts in that case, but there are takeaways that you might want to consider. In that case, there was a special permit application that was filed for a drive-through restaurant on Farmington Avenue in Hartford. And staff determined that the regulation the application was insufficient and denied it. And there were some provisions of the regulations regarding the authority of staff to make administrative decisions. That decision was not appealed to the ZBA. Subsequently, zoning regulations were adopted that prohibited that particular use, and there were appeals in that case. The Superior Court ruled that because there was no appeal of the staff's decision to the ZBA, there was a failure to exhaust, and the denial of the special permit stood. But on the other hand, if it didn't, if that application was just hanging out there, then it would be subject to the regulations that were in place at that time, and the subsequent zoning regulations would not apply to it. The appellate court agreed with the trial court, but the Supreme Court, on the other hand, found that the zoning staff had no authority to act on a special permit, that had to go to the commission. So regardless of how defective the application was, the court, using some Latin, found that it was ultra virus and void ab initio, which essentially it was an illegal action, and it's as if it never occurred. So the special permit application, even though it had been sitting out there for a long time, and as you probably know, there's no automatic approval for a special permit, that needed to be acted on in accordance with the regulations in existence then. So the takeaway from that is regardless of what your regulations might say or what your practice is, if you're dealing with a special permit and you find that the application is woefully defective and you would ordinarily deny it, get it on the commission's agenda and make sure the commission makes a ruling to deny it for whatever defects are there, so that you can protect against being subject to regulations in place at that time, regardless of subsequent zoning regulation changes. Turning to some aspects of the legislation that has been adopted that relates to land use, there is regulations, and first time I had a presentation that included talking about marijuana. So there's an entire act that was adopted for recreational marijuana. And there's one section in there that's of particular note from a zoning enforcement standpoint, and one that gives us concern and advises very strongly that the municipalities put in place a moratorium so that they can figure out how and if they want to regulate it. What it provides for is that a town can, through its zoning regulations, prohibit it altogether It could impose restrictions of hours and signage, could regulate the proximity of cannabis establishments similar to what is in place for liquor stores in Connecticut. It does have a limitation that there be only one in a municipality for every 25,000 people. So for small towns, there can only be one. The most troubling part of this section is that in its section 148 of what will be the chapter involving recreational cannabis, is that it says that unless otherwise provided for by a municipality through its zoning regulations or ordinances, a cannabis establishment shall be zoned as if for any other similar use other than a cannabis establishment would be zoned. Difficult language to struggle with, but it seems that it's intended to provide that it would be allowed by right and be treated like a similar use. That could be just simply a retailer. Anywhere where you're allowing retail, you could have retail sale of medical marijuana. It's not clear at what point in time that would kick in. So to avoid the risk of someone, even before the standards are adopted for how these facilities are going to be permitted and operated, we strongly encourage putting a moratorium in place so that you can see what the standards are, and the commission can consider, the zoning commission or planning and zoning commission could consider whether it wants to place any limitations on it and how. There are also two acts that were adopted related to outdoor dining. One is a special act that's going to apply between now and March, the end of March in 2022. And that essentially mimics the executive order with respect to outdoor dining. It gives the simplified process for adopting zoning regulations where you don't have to submit for COG review. It provides for the action on applications by the zoning enforcement officer that limits what can be required. There's no specific site plan or traffic studies or stormwater management reports. It just requires essentially a plan. It could be a hand-drawn plan that shows how it is going to be operated, and the zoning enforcement officer has the 10 days to make a decision. If no decision is made, it's automatically approved. And then it also, if it is denied and appealed, the appeal goes to the zoning commission or planning and zoning commission. It has provisions, for the sake of time, won't go through all of the great detail, but it has provisions in there how to deal with road closures and having the outdoor dining existing in rights of way, both town and state rights of way. So that's Bill 6610. Then there was also a general statute that was adopted, which was Senate Bill 1202, and that deals with the world after April of 2022. And what that provides for is that the outdoor dining must be permitted as an as-of-right use, accessory to places that serve food and beverages. And one exception is if the restaurant or food service business exists as a non-conforming use. It pre-existed, maybe in a residential zone, pre-existed it. It would not apply to that. It wouldn't be able to expand the non-conforming use. But if it's a permitted use, either by special permit or by site plan or otherwise, the regulations must provide for it to be an authorized accessory use. Regulations can be adopted, so you've got a little time to consider that. So regulations regarding what kind of enclosures would need to be used, lighting, signage, amplified sound, essentially regulating. The use has to be allowed, but you could regulate the use. So you've got a little time to do that. Again, for the sake of time, I won't go through all of them, but there are also provisions of how the use will be regulated when it is going to take place or proposed to take place on public highways, both local and state. And those are a couple of the legislative changes that I was going to cover, and I'll turn it over to Rich.
Thanks very much. Just kind of quickly, in using the soccer term, during extra time in the special session, the legislature passed a number of things in the implementer bill that did not make it through during the regular session. One of them was establishment of the GIS office within OPM. That's found, and again, the bill number for that is Senate Bill 1202. I don't know the public act number. I looked this morning and it hadn't been assigned yet. Sections 90 through 92 of the implementer bill 1202 established the GIS office within OPM, sets up an individual to be appointed as the Geographic Information Officer of the state. One of the questions that came in ahead of time was how many positions are being funded. It looked like during the first year of the budget, they're essentially funding 2 positions half-time on the assumption that it'll take a while to fill the positions. But during the 22-23 fiscal year, they were looking to fully fund both of the positions. That was the fiscal note anyway. In addition to creating the GIS office, there will be established a GIS Advisory Council with a number of representatives from DEEP, Department of Transportation, DESPI, the state's Chief Information Officer, Department of Public Health, regional COGS, municipal governments, Yukon, and so forth. So while it appeared that the GIS bill did not make it through the regular session, it was picked up in the implementer bill. So that has become law. A couple of the other bills that became relevant, the concern arose during the life under executive orders as to what would happen to approvals or permits that were scheduled to expire during the state of emergency. And there was language in the executive orders that essentially told those approvals through the extension of the pandemic so that they wouldn't all necessarily expire while town halls were closed and people would be unable to do anything about it. There had been conversations with the governor's office and DECD and some other agencies about trying to find ways to create a mechanism by which permits could be extended so that, you know, for example, they wouldn't all expire on the day after the state of emergency ends. And the template that was chosen by the legislature and I believe by the governor's office as well was the extension that was used on site plan and subdivision approvals back 10 years ago or so, where additional time was granted to the lifespan of land use approvals. And there are 2 separate bills, 2 separate public acts that deal with extensions to the expiration date of land use approvals. And they're a little bit complicated. They're a little bit disjointed. Public Act 21-163 addresses site plans, subdivision, and wetlands approvals that were granted prior to July 1st, 2011 that have not otherwise expired. And essentially that bill provides that the expiration date on those approvals is automatically kicked out to 14 years from the date of approval with the opportunity to extend up to an additional 5 years for a total of 19 years. Public Act 2134 addresses similar concerns with respect to site plan, subdivision, and wetlands approvals that were granted prior to the effective date of the act, which is today. Were granted after July 1, 2011, and did not expire prior to March 10th, 2020, which was the date on which the state of emergency was declared. Likewise, those approvals have been extended by the legislature to expire not less than 14 years from the date of approval, again, with the opportunity to seek additional extensions to get it up to a lifespan of 19 years. In addition to those relatively straightforward extension provisions, there are a couple changes that are different and a little bit more complicated. One of them in Public Act 2134 deals with wetland approvals that are being obtained in conjunction with project approvals that otherwise require either a planning or zoning or planning and zoning approvals. And what that provision does is said that the wetlands permits do not take effect and their clock doesn't start running until they have obtained the other planning and or zoning approvals, and that they're good for at least 10 years or the length of whatever planning and zoning approval there is. So I guess the theory here is that if you get your wetlands approval and it takes you 2 years more to get your site plan approval, the idea is you don't lose 2 years of the validity of your wetlands approval while you were going through the process of getting either the site plan or the subdivision approval. One other interesting change that was made both in 21-163 and 21-34 pertains to special permit approvals. There was a case relatively recently that kind of as a surprise to some and not to others, and others are probably generally oblivious to it, dealt with the issue of whether it was permissible to have a time expiration date on a special permit approval or whether they run with the land and are theoretically perpetual. So what the two public acts this year did was essentially validate for at least 19 years any special permit approval that was granted either before or after July 1st, 2011, which had not already expired, that in its terms was subject to a specific deadline to complete the work. So, you know, if you got a special permit approval in 2017 that said you needed to finish the work within 2 years, or 5 years, probably more appropriately. So the expectation would be that your special permit by its terms would expire in 2022. This statute essentially says not so fast. Special permits granted prior to the effective date that have an expiration date tied to completion of the work are valid for not less than 19 years. And it actually provides the opportunity for additional extensions beyond that. Frankly, I think this, you know, these legislative changes kind of came as a surprise even to the people who were advocating them because they, you know, appeared to be going nowhere in the legislature. And one of them was sort of tacked into the, I think it was an eviction bill. So this is definitely something that, you know, that is relevant to calculating and determining the expiration date of site plan, subdivision, wetlands, and special permit approvals that have not already expired. Again, I think the thought on in general was that they didn't want to punish people whose permits were going to expire during the term of the pandemic, and that they were given an extension. And maybe on the theory of go big or go home, they ended up giving much longer extensions on the validity of these permits than I think people had anticipated. One other thing that was in the implementer bill is much of the contents of the ultimate language in House Bill 6448 as amended by House Amendment A that dealt with remote and virtual meetings. And you know, it's kind of nice now that it's July 1st that you have a statute that tells you how to run public meetings at least through April 30th of 2022, rather than living under the executive orders on kind of a month-by-month basis, trying to decide what's going to happen, what can we count on for next month, how do we plan for all the various alternatives. The other thing to bear in mind is that with the expiration of the executive orders, a lot of the conveniences or exceptions that were provided by the executive orders, particularly 7I-19 that dealt with a lot of the land use issues, expired as of midnight last night. So once again, municipalities are going to be subsidizing the newspaper industry by publishing notices and notices of meetings, notices of decisions in the newspapers again, rather than being allowed to solely post them on your website. One of the questions before the seminar was why, and I guess the answer is, as it has been for a number of years, that the newspapers have very good lobbyists and don't necessarily want to lose that lucrative revenue source. With respect to public meetings going forward, I think the key takeaway is that you are allowed now to do in-person meetings, and as a general rule, the in-person meetings would be run the same way they were on February 1st, 2020. Comply with FOIA and all of the requirements contained in the Freedom of Information Act. The one kind of minor glitch or minor wrinkle on that is that if a member of your board or commission chooses to participate remotely, you have to make that opportunity available to the member. The general understanding was that it was permissible for board or commission members to participate remotely by telephone or Zoom, but although nobody knew what Zoom was 2 years ago, under a Freedom of Information Advisory opinion from 1980 that allowed kind of the speakerphone participation. But now it's frankly mandatory that if you have a member of the board or commission who wishes to participate in an otherwise in-person meeting by means of electronic technology, that it has to be allowed. I think one important thing is that by virtue of simply allowing one or more of your members to participate remotely, it doesn't automatically convert it into a hybrid meeting, triggering all of the requirements that I'll go over in a second. First off, you are allowed to have in-person meetings. Second, you are also permitted to have either hybrid or entirely remote meetings going forward. Key things that are different from under the executive orders are now that if you intend to have a public meeting that is either hybrid or remote, either entirely or partially by means of electronic equipment, you have to post a notice to that effect on the town website and in the town hall at least 48 hours before the meeting, indicating how a member of the public can get into the meeting. You're also obligated to notify members of the agency at least 48 hours in advance that the meeting will be held either entirely or partially by electronic means. That's something new that was not required under the executive orders. The provision regarding publishing and posting on the website and at the town hall the notice of your meeting 24 hours in advance, the agenda and so forth, including information for members of the public to be able to access it by electronic means. That's the same as essentially a requirement under FOIA and essentially the same as the requirement under the executive orders. So 48 hours, you have to post the notice that you're going to be running the meeting by remote means. 24 hours in advance, you post the agenda. And both times, I think it would be prudent to include the information on access. One thing that is also different from the executive orders under the statutes is that even if you're having the meeting remotely, entirely remotely or on a hybrid basis, you're not obligated to post on the town website all of the materials relevant to the meeting 24 hours in advance, the way you had been under the executive orders. It's not a bad idea if you have the staff, if you have the bandwidth to do it. It's a helpful thing for members of the commission and for members of the public to be able to see what's going on other than just a list of items. But it is no longer required. And I know that it had gotten to be kind of a problematic for some boards and commissions where materials were not posted sufficiently far in advance, so they may have been unable to take action on certain items just because it didn't get posted until the morning of the meeting rather than the afternoon before. That requirement goes away. One or two additional requirements where you're having a regular meeting solely by means of electronic technology. So if it's an entirely Zoom meeting with no members attending in person, you have to provide a member of the public, if they make the request at least 24 hours in advance, you have to provide a member of the public who wishes to attend with a location and with the electronic technology required to allow them to participate in the meeting. So if you're going to be having a Zoom meeting and there's some member of the public who says, I don't have a phone, I don't have the internet, and they give you the required 24 hours notice, the town's obligated to find a place for them where they can monitor the meeting, and you provide the electronic technology that is necessary to allow them to participate to the same extent that they would if they were at the meeting in person. One of the other things that is required if you're doing the fully remote meeting is that either the recording or the transcript of the meeting has to be posted on the town's website within 7 days of the meeting. And once it's posted, it has to remain there at least 45 days. A lot of municipalities were starting to have issues with storage capacity, cloud storage, server capacity, and so forth. So the 45-day retention on the website provision was kind of a compromise. The same information, either the transcript or the recording, also has to be made available at the agency's place of business. So if you have a land use office or a town clerk's office where people would go, you have to provide them with either the transcript or some way of either seeing or downloading the meeting during that same 7 to 45-day period. Special meetings, essentially the same rule as public meetings, except special meetings under FOIA, you're not obligated to provide the notice more than 24 hours in advance, so you don't have the 48-hour provision that was the case for an entirely or partially remote regular meeting. If there are votes that are going to be taken during either a hybrid or a remote meeting, and the vote is anything other than unanimous, it has to be taken by a roll call vote so that anybody can hear and or see who on the agency votes either way on things. If there are people participating remotely and in person, the minutes have to reflect in which manner the members were participating. And one of the other things that had come up during the life of the executive orders that has also been clarified by the statute is that even though members of the public are allowed to view and hear the meeting and participate by electronic means, the extent of the public participation is limited to the same type and amount of participation that they would have had if the meeting were fully in person. It doesn't create, additional opportunities for public comment where none would otherwise exist. So it's essentially access to the meeting, but it doesn't create any greater opportunities for public participation than otherwise would be the case. One of the things that had been in the executive orders and was continued forward in the Public Act is that members of the public and members of the agency, when they are speaking, are supposed to make a good faith effort to identify themselves when they're speaking. And this is obviously for, for hybrid or remote meetings. If you're there in person, people are going to be able to see who's speaking. But, when you're calling on people or when people are making statements during the meetings, the idea is that there should be some method of identifying them. One of the last items that's covered in the statute is if for whatever reason the meeting breaks down because there's a problem with the quality of the connection. If it gets to the point where you lose a quorum or people can't participate or the server is down or something like that, the agency has the opportunity to through the chairman kind of terminate the meeting, and they have the opportunity not less than 30 minutes nor more than 2 hours later to resume the meeting, so that they can kind of sort through whatever the power outage or the disconnection issues might be. During the meantime, there's supposed to be some effort made to notify anybody who had been at the meeting when and how you anticipate resuming the meeting. It could be something as simple as, the Zoom server at Town Hall went out. We're gonna meet there in person in an hour. And you can resume the meeting that way so long as a quorum is present, or you can, resume the meeting remotely as well, as long as, the information is provided and a quorum is there. One of the things that's key there is that if your meeting has been interrupted and resumed, you can't take up items that were not on the agenda. So the thinking is that you don't want people being surprised. They get booted off a Zoom meeting and then suddenly, they find out the next day or 7 days later that action was taken on things that were added to the agenda while there was the turmoil of the meeting. And I think the last thing that's worth mentioning is that in addition to the existing FOIA provisions regarding throwing out of a meeting members of the public who are disruptive or acting in a disorderly way, there is the same provision in the new law for bouncing people out of a Zoom meeting who are either Zoom bombing or otherwise disrupting the proceedings. That's kind of the long and short of it, but with that, I will stop. I guess everybody went home.
Do we come back on?
So,
Yeah.
yeah, I think there were a number of questions in the question and answer. And I don't know if Sarah was able to answer some of these. You want to jump in on some of the answers, or Nick, to give Rich a chance to hydrate himself and before he tackles some of these. Sarah and Nick, you guys want to look through some of the Q&A?
Yeah, there were a few on accessory apartments, and a lot of them are in the answered column, but one of them that I'd be interested to hear what Ken and Rich have to say actually is the one from William Agresta, who asks, what do we do with non-conforming single family dwellings, let's say in an industrial zone? So the language of the bill says that, or the Public Act says that the municipality has to require an accessory apartment on a single family house. Later, it says that an approval of such an apartment cannot be conditioned on the correction of a non-conforming use. But of course, later on in state law, is the prohibition on expanding a non-conforming use. So you do have those two considerations. If you add an accessory apartment, arguably you're expanding a non-conforming use because you're making a use denser, even if you're just using the single family, the attached structure. So I'd be interested to hear what you all think about that specific issue. My take is, well, I don't know. Go ahead.
The one interesting thing is they made a specific provision for that in the other bill regarding outdoor dining, where specifically said that's not going to be permitted by right if it's a non-conforming use. They don't make any specific provision like that in the accessory use. So it's an interesting question. I would lean towards saying that it's not intended to allow for an expansion of a non-conforming use in an industrial zone, but it's not perfectly clear to me.
Well, then it's interesting because I hadn't read the outdoor dining language closely. The fact that the legislature knew how to say that and then didn't say that for accessory apartments actually, to me, says that a municipality should allow an accessory apartment in a non-conforming existing building, but wouldn't, so you wouldn't be able to expand the structure necessarily, build a new carriage house, apartment in the backyard. But if this legislature did that for dining, they should have done it for this if we really wanted to be clear. So I would say to William, my take would be, if the property owner came in, he would or she would have to be allowed to have the accessory unit in the main structure, but couldn't you don't have to permit them to have it outside.
And I agree with that. Also, it's the expansion of the footprint of the building. I think that would be more likely to interpret allowing it within, but it's not perfectly clear. And I would rely exactly on what you said, Sarah, about the fact that they did it in one place and not the other. Maybe that's what their intent was, but that's going to give some lawyers something to do when that comes down the pike. I like Marty Connor's question, and I don't know where folks think about the question. Torrington has got 40,000 people. On the cannabis bill, you have to have one facility for every 25,000 people. Obviously, you have less than 25,000 people, you get to have one. You don't have to hit the 25,000 mark. So when you're between 25 and 50, do you get two facilities? Or do you have to you're allowed one up to 25, and then you have to be a 50,000 or more town in order to have two cannabis establishments in town. Any thoughts on that?
I forgot the exact wording. I mean, I think it's written in such a way that if your town is under 25,000, you don't have to have, or you can't have more than one until 2024. I mean, does that mean if you have 25,001 people in your town, you can have 18 of them?
No, I think the language is that no municipality should grant a zoning approval for more retailers or micro cultivators than a number that would allow for one retailer or one multi-cultivator for every 25,000 residents of such municipality. So certainly they can have the one, any town under 25,000, but if you have a town of 26,000, does that allow you to have two? Or in that, you have that gap. So someone's going to have to fight about that one too, I think.
Or you can have 1.04 of them.
Well, that's interesting because so Hartford, and I know Amy Chambers is on the line too. Hartford has allowed for several years dispensaries to be treated like other retailers. We don't have, I don't even know if we have any in Hartford. But that new law would actually put a cap on the number that we could theoretically permit here. So anyway, that's interesting. I have to read that one. There's some questions for you guys about extensions. There's one from Jerry Burns. I don't know if you see that on the extensions issue. And there's a couple others on meeting minutes. Those are maybe more timely than some of the ones that we've answered. On meeting postings, rather.
All right, so if you had an approval prior to 2011 that had the final extension in 2016, would have expired this year, Can they now request an additional 5 years? Yeah, I would say yes. If it hasn't already expired, I think they can ask for the additional 5.
Patrice also had a question about whether towns should post Zoom meeting information on the website rather than supplying it to people who RSVP.
I think as long as it's made available to somebody in one form or another. I know that towns that did town meetings by Zoom quite often required people to register in advance so that they could give them, the specific link rather than, posting it on the website, just to try to manage attendance to limit it to people who are eligible to participate. I don't think in a regular public hearing, you have the same eligibility requirements, but it is, if you haven't had the pleasure of being Zoom bombed, it certainly makes you think twice about providing ways to, to avoid having it happen again. It's kind of disconcerting.
Aaron Peck asked the question about whether a staff member can attend remotely. I assume it referring to an in-person meeting, in which case there's existing FOI policy that members can participate remotely in an in-person meeting. I don't see any reason why a staff person wouldn't be subject to that same umbrella and would be able to participate in a purely in-person meeting by way of telephone or another mechanism. Is there anything, Rich, in the bill that you disagree with that on?
No, I think where you need to be careful is whether the level of remote participation by the public gets to the point where it morphs it into a hybrid meeting.
Great, and I just put a link in the chat about vehicle miles traveled because there were a couple of questions about that, and we do have a page that's linked from that HB 6107 page specifically about VMTs.
I'll also just chime in. There were a couple of questions about accessory dwelling units, whether towns can allow them to can only allow attached or detached. I think some people were reading the statutory language itself, and there might have been some ambiguity, but our reading and the reading of OLR is that the bill requires towns to allow attached and detached accessory dwelling units, including ADUs that are contained within the principal dwelling, not just one of those.
There was one question in there, what else expired other than the newspaper publishing? I mean, Sarah and I were there at the beginning trying to remember all of the things that were in 7I-19. I think they included being able to send certain things by email rather than regular mail, because at the time it was written, there, the concern was that town halls were closed, so you wouldn't be able to get the abutter list in a timely manner. There were also some provisions regarding where you'd be able to post signs rather than mail letters to the neighbors. You were able to send emails rather than certified letters. Those things all evaporated with the pumpkins last night at midnight. So.
And Patrice has another question too about single family housing and potential conflicts between requiring the allowance of accessory apartments and water pollution control authority requirements. The statute only addresses zoning authority, the HB 6107. So what it says is that you can't prohibit accessory apartments through zoning. But of course, if there are other authorities that can opine or limit, then that is not affected by 6107. It doesn't give the property owner a right to override anything outside the zoning authority.
And that would particularly come into play if you have a detached accessory that would presumably require its own septic or well or of that sort of thing. If it can't
Except
connect it.
except that we didn't say that today, but that is included. If it requires its own septic, that's one thing. But there is a provision in the bill that allows for single family, the main dwelling and the accessory to be on one system without it counting as a community sewerage system. So in other words, as long as the whatever authority, the public health authority or the water pollution control authority opines on the capacity of a sewage system, as long as they're okay with the capacity number, it can be combined into one septic system according to the bill without triggering more onerous review under the community sewerage standards.
Okay, well, I think we answered most of the questions that were in the chat or the question and answer session. So I just want to take this time, first of all, to thank all of our participants who came. We really appreciate you guys taking time out of your schedule. Sarah, I appreciate you coming on here today, knowing you had dental surgery. Thank you so much. Ken, Rich, thank you. And to all of our members who are on here, I know we touched a little bit on the cannabis bill today. We are planning on doing something later in the summer with a more in-depth kind of look at that cannabis bill and what it contains, what it doesn't, what it means for municipalities, and maybe some thoughts and recommendations. So I'm thinking, Mike, you can kind of chime in here. We were thinking August for that.
Yeah, we're hoping either late July or sometime in August, and we can pull together another sort of panel approach. So stay tuned on that.
Right. So that will be, blasted out by CAZEO. If CCAPA is interested in that, maybe we can do another kind of dual seminar like today. This went really well, and I appreciate everybody's efforts pulling it all together. So, John, did you have anything you wanted to add?
No, just that anytime CAZEO wants to put together a presentation, we're happy to take partial credit for it.
Thank you. All right, everyone. Have a wonderful afternoon, and thank you so much.
Take care. Thank you.
Here.
Thanks, everyone.